that cat?
Archer.
You're just gonna stare at me?
Oh.
And rollers. What the hell?
Hey, what's going on, everybody? It is Artie of Artie's Corporate Fiction. Happy to have you guys back on again today. As promised, we're going to finish up the Michael McDonald saga. Well, hopefully. I don't want to go on the whole time. I think there's about I'm hoping there's only about well, actually, I don't think we're actually going to be able to get through all of it, because I think that we are going to go through his trial for the forgery and related stuff. And I think the trial itself is like 4 hours long. So I'm not going to be streaming for that long, for sure. I was probably thinking we'll be on for maybe 2 hours. I want to get as much Starfield as I can before the weekend's over, you know? But another point of interest, I am now kind of going pretty whole hog into Twitch. Oh my God, Sathail, stop. Twitch and YouTube, Twitch and Kick. If you guys don't know, oh my God, Sathail, thank you for the 50 gifted memberships, you crazy, insane person. Didn't even let me finish my intro. Thank you, though. But I was gonna say is that oh my God. I'm kind of moving into Kick and Twitch. YouTube's quality isn't exactly doing a good job right now. It's kind of annoying. So with that being said, looking at other platforms to be able to do as well. So with that being said, the thing is with Kick, I'm not yet monetized. So right now, I need 75. Why does it say 0? I need 75 followers on Kick in order to be able to turn on subscriptions. So that's why I have the little meter up there. So if you guys want to join in on my Kick platform, it's basically a Twitch alternative, but it's the same thing, live streaming platform. So if you guys could have the chance to watch me on 3 different platforms, just in case one of them decides to sputter out. So anyway, we're gonna keep on going. This is like the event video that's gonna highlight why we're back here with Mr. McDonald and the ensuing charges that come with that. But either way, thank you so much, Sathail, for the gift. Is much appreciated. We're gonna start it right now. Where is it?
Alex here with another event on the state of Nevada versus Michael McDonald. We left off on July 22nd, 2019, broadcasting live from Department 28 of the 8th Judicial District Court. Senior Judge Kathy Hardcastle presided over the matter because District Judge Ronald Israel was out for a medical procedure. Ms. Hardcastle heard the state's motion to order Mr. McDonald remanded back into custody and granted that motion. The hearing ended with a scuffle between Mr. McDonald and a half-dozen deputies. It looks
that's why.
Here we go. Has continued to rise. We have 25,300 1,500 watch time minutes on YouTube combined with 3.6 thousand views. And those are just the analytics for YouTube. Specific to Facebook, there are multiple thousand views on both of the hearings, the ones covered on July 10th, 2019 and July 22nd, 2019. There is a trial in this case September 3rd, 2019 at 10:30 a.m. We do intend to appear and broadcast. There is a calendar call on August 26th, which we will send a representative to. It may actually occur that on that date the trial is moved, so keep an eye out for any updates from us on both Facebook and YouTube. It is anticipated that this time District Judge Ronald Israel will be presiding. It looks like Karen Mishler will appear again for the third time, at least as far as we have covered, for the state of Nevada, and Craig Mueller, it appears, will be representing Mr. McDonald. Of course, keep an eye on the Facebook page as these little details may update as well. Because this is a formal jury trial, you will
I'll make sure to add you as a moderator.
Witnesses, and the jury themselves will be making a determination as to whether or not Mr. McDonald is guilty or not guilty on the 11
Hey, Jester.
he is facing.
Hey, Iki Taku on Twitch. Oh my God. How you doing, man? Long time no see. I will. Ikitaku, Alpha says hi. Hey, Juzam 48. No, this is the this is from the from our Nevada judges, guys. Kick, as in kick. Mandy, can you make a command or with a link to the by URL on Kick? I don't think that's that we have that yet. All right, that's all right. We got it. We got you.
Let's hear with some updates on the state of Nevada versus.
Oh, there's been a filing here.
9 a.m. We would like to let our viewers know of a few more recent developments as well. On August 28th, the defendant filed, through and by his attorney, a formal written motion seeking to revoke our media access. If granted, we would not be able to provide coverage of the proceedings.
Oh, that's right.
Necessarily broadcast them live. The reasons cited are based mainly on the stress that the defendant is suffering due to the fact that cameras are in the courtroom pointed at him. On August 30th, we went ahead and filed a formal written opposition to that motion, citing precedent established in 2017, where the Supreme Court of Nevada ruled, number one, that there is a presumption that electronic coverage of proceedings is allowed if those proceedings are open to the public, and number two, that there is no exception in place where a party or even a party's attorney claims that they would be distracted or otherwise stressed out by the fact that cameras were in the courtroom. You can go ahead and look down in the description below for the links to both of these documents. You can click on.
No worries, Manny.
Take a look at them for yourselves. If you have any questions as to the details that we didn't cover in those documents, go ahead and post those questions down in the comments below. We will answer them to the best of our ability. We do not anticipate that this district judge will revoke our media access. We do anticipate that most likely we will be able to provide coverage of these proceedings. However, we did want to at least let you know, because it is a possibility, slim as it may be, that we will not be able to provide coverage of these proceedings. If you have any further questions, feel free to send them to us at admin@ournevadajudges.com. And as always, you can keep track of any last-minute updates on our Facebook page.
Yeah, that's also the other good point. Kick right now does not have any ads at all. So
Good afternoon.
all right.
I didn't even have the case caption. Thank you. C335284, State versus Michael McDonald. Counsel, state your appearance for the record.
Craig Mueller, behalf of Mr. McDonald.
Karen Nischler and Brandon Albright on behalf of the state.
Your Honor, additionally, Mr. John Schaller, a New York attorney, recently passed a Nevada bar, just took his NPR results and is supposed to get him Wednesday or Thursday. He's going to be sitting, with court permission, to be sitting with the counsel table with me. Keep track of the paperwork.
Same case. This is a motion. This is a motion on whether or not to revoke media access.
So let's start first with the motion to,
Oh my God, I forgot.
more or less, the motion to exclude the media.
All right, I have this at 1.25 speed.
Go ahead.
Thank you, Your Honor. I'm not excluding the media. This
Well, video.
is, respectfully, Judge, I was around actually as a younger lawyer when we had the debates about letting the cameras in the courtroom. The consensus was that they would cause people to behave or to distort the process. That, for the most part, turned out not to be true. And it has been my experience that generally press interest in cases is generally good for the system and it keeps things going forward. Having said that, I've done about 5 or 6 death penalty cases, a couple very high profile political cases. I've had cases that have been in the press all the time. I have never breathed a word of objection about having the press in the courtroom. Unfortunately, at this time, I do have to object. This is not, in fact, the press. This group of people is a clique, social, political clique. They run out of family court. They used to be called Judicial Watch, now they're called our Nevada Judges. This purpose of this exercise is not to enlighten or to inform or to do anything to improve the
Nathaniel, thank you for the 5
exercise.
Twitch subs.
And to make sure they've got a video camera if Michael McDonald loses his temper. And when I said that on Friday or before the last court date, I got a 10:30 a.m. text from a mutual acquaintance, actually forwarding me their video to make sure that I'm not exaggerating this. This is from a real estate agent who I'm casually acquainted with from the Boy Scouts. She actually sent me the link. Would you like to see what they've posted last time regarding these proceedings?
I think they do have Alex testify in this one.
Yes.
I found this morning when I woke up this morning off my Facebook. Now, you can watch their production.
We left off on July 22nd, 2019, broadcasting live from Department 28 of the 8th District District Court. Senior Judge Kathy Hardcastle presided over the matter because District Judge Ronald Israel was out for medical procedure. Ms. Hardcastle heard the state's motion to order Mr. McDonald remanded back into custody and granted that motion. The hearing may be still between Mr. McDonald and the appellate deputies. It looks like interest in the case has continued to rise. We have 1,300 watch time minutes on YouTube, combined with 26,000 views. And over just the analytics according to specific to Facebook, there are multiple thousand views on both of the hearings, the ones covered on July 10, 2019 and July 22nd, 2019. There is a trial in this case September 3rd, 2019 at 10:30 a.m. You do intend to appear in broadcast. There is a calendar call on August 26th, which we will send the representative. It may actually occur that on that date, the trial is moving. So keep an eye out for any updates from us on Facebook and YouTube. It is anticipated that this time,
Here we go.
Judge Ronald Israel will be presiding. It looks like Karen Nischler will appear again for the third time, at least as far the state of Nevada, and Greg Mueller. It appears will be representing Mr. McDonald. Of course, keep an eye on.
Thanks, Paul. Thank you for the 500 biddies.
As well, because this is a formal jury trial.
Like on all 3 platforms. Uh-oh.
Witnesses and the jury themselves will be making a determination as to whether or not Mr. McDonald is guilty or not guilty on the felony counts in this case.
Thank you. Have you seen this, State?
No, Your Honor.
That, hopefully you could hear it. There wasn't,
Yes.
all it was a face with that. Go ahead. You want to see it again? You want to see it? Go ahead.
I have the volume turned all the way up.
I get it, just Your Honor.
It's on YouTube as what?
YouTube, Facebook, this isn't, and Your Honor, respectfully, these gentlemen are welcome to stay in the courtroom and report and ask questions. My defense is not complaining about the press in the courtroom. That's not what the purpose of this is. This is to get sensational videotape. Now, there's not any reason. This is a clique of people that they follow family court, and they are gleefully up here watching Mr. McDonald. This is against the background of this case. You may recall, this is the first time in 30-something year career I've ever seen anybody being charged with falsifying documents in family court, one of which is substantively true, and the other one supposedly on his financial affidavits. So that's it. This is not a man with a criminal record. This is a man who hasn't been allowed to see his kids, and they're going to sit here and poke at him emotionally until he cooks off, and they're going to get it on videotape, and they're going to gleefully post it. That's not going to add to the proceedings. Now, in a very narrow fact, this issue presented in this case is were the documents fraudulent or forgery, or was there an attempt to forge them or not? Now, I previously moved to dismiss this charge on vindictive prosecution. We've heard you give me a fair day in court. I won't litigate that. But respectfully, Judge, I've never even heard of a family court judge just not taking action themselves and referring it to the state or the district attorney's office. That's against the extraordinary background of the district attorney's office seeking to intervene into a family court case, which I don't know. I've never even heard of such a thing, or that's procedurally allowed. Fortunately, Judge Henderson ruled that it was not. Now, this is bear baiting. It is not a solemn trial of a vindication of constitutional rights versus the rights of our community. This is nothing more than poking at an emotionally distraught man on a very narrow theory of liability. And I told my colleagues this. In my career, $80,000 embezzlement case. District attorney's office can't get bothered with it, says it's a civil matter. Future Judge David Barker allows a woman with a $325,000 embezzlement case from her boss to get a gross misdemeanor. Now,
Thank you for the gifted membership.
I've seen traditionally done by the district attorney's office, and I'm standing here defending a man on 2 theories of liability. One, the affidavit that he turned in that the judge said, or the author said was true, but he added a couple words to it for clarification in a case he's litigating by himself is actually a fraud. And secondarily, that his financial affidavit, when he doesn't have a job, isn't correct. Now, this is vindictive prosecution. It is an unusual, at best, theory of criminal liability. The narrow issues that the state's going to have to prevail on are very narrow, and I do not see that the ends of justice are served by having this camera and turning this into a circus.
2 things before I let the state talk. Did you get the opposition filed by, well, I think it was filed by the individual who runs or owns that company?
I saw that the one was filed on the way to court this morning. I've not had a chance to look at it.
Can you?
They are, Iki. How you doing, man?
Copy of it?
It's been like ages.
All right. Tell them to make, have you seen a copy?
The state has, Your Honor.
Okay. You have extra copies? Are you Mr. what, Falcone?
Oh, there he is.
Do you have extra copies to give?
The legend.
No, I just brought one for myself. You can have it.
You can, I've read it. Now give it to Mr. Mueller. Thank you.
He does this a lot.
Best interest is not, can you give her a pony?
Guys,
I'm going to ask the question, make sure we're being accurate with what Dr. states.
guys, if the if the live stream on YouTube is really messing up, this is actually the other reason why I'm now like multi-streaming on Kick and Twitch. Apparently YouTube has had some serious issues this weekend. So if you're able to, you could check me out on Kick or Twitch this evening.
To find out what the facts were.
I forgot they did these intros a lot in the early days.
Here, one motion.
Does the state have a position since he's reading that at all?
No, Your Honor, the state has no position on the allowances and the media in the courtroom proceedings.
And the second issue, counsel approach.
Be distracted by the cameras in the courtroom. Now, we make no pretense, and the court clearly is well aware of the emotional state of Mr. McDonald. This is a hideously inflamed divorce proceeding. Now, having said that, if this case becomes an emotional circus, justice will not be done. This is a very narrow theory of liability that the state has to establish. I'm deeply skeptical that they can do so.
All right, people saying Twitch is the most stable right now.
And not to get involved with all the who shot Johnny that's going on with this case. This case I've never seen so many procedural irregularities, let alone seen them all in one case. The district attorney tries to intervene in a family law case. I mean, really? A district court judge down at family court won't enforce their own orders? Really? We're up here trying to a jury trial where we're stacked up on murder cases. We're doing a jury trial on whether a document that is conceitedly correct in substance, if not procedure, is a forgery, and we're up here deciding whether a guy who wasn't working was actually indigent. He doesn't have enough money to hire an attorney, so now he's going to be held accountable for documents on that account. Now, that's 4 procedural irregularities, none of which I've ever seen before. Then we had this circus showing up and wanting to film every aspect of it. I don't believe this is a trial in any sort of proceedings that I've been familiar with. And I've shared with you the other 2 or 3 financial crimes I've done in the last few years. It's inconceivable that the office that couldn't prosecute a $325,000 embezzlement really wants to hang a felony on this guy's, Mr. McDonald's head.
It could. The other issue is it could also be me trying to stream on 3 different platforms. Damn it. I'm gonna give this a few more minutes, and then if it keeps on going like this, I will probably try to drop Twitch for now. Yeah. And then stick with Kick and YouTube, I think. But we'll see.
Now, I know it's a big organization anymore, and Mr. Left Hand really knows what Mr. Right Hand's doing, but at a certain point, this lapses into vindictive prosecution.
All right, thank you. The case and the Supreme Court rule clearly outline both the, if you will, rights or burdens. Number one is there's a presumption that the courtroom proceedings are open and can be televised. That's exactly what was going on in the Solid case. The findings, if you will, are the impact of coverage upon the right of any party to a fair trial. they, both in that case and in this case, we will be picking a jury, and I don't see that the photography, the video, whatever you say, is going to be impacting the jurors. And your arguments are well taken that this isn't a high-profile trial, and despite the YouTube or Facebook or whatever it was hits, all that means is that it's salacious, the fight, and that's why people looked at it. That's, of course, all too common, but that is not going to, well, we certainly are hopeful that is not going to happen. We will have a calm and organized trial. B, the impact of coverage upon the right of privacy of any party or witness. Mr., how do you say your name?
Alexander Falcone.
Mr. Falcone,
Yeah.
one thing, well, certainly one thing you may or may not have been aware of, you are not allowed to take pictures. The camera will not, better not include any of the jury, and you won't be allowed during jury selection to videotape because they're moving around too much and there's too much going on to preclude you. Jurors are coming and going all the time, and unless you are
Hey guys.
extremely careful, you would be taking pictures of potential jurors, which is not allowed. Second of all, witnesses, unless they give you specific permission, you're not allowed to take their pictures. You can use the sound, that's fine, but you're not allowed to do that. C, the impact of coverage on the safety and the well-being of the party, witnesses, or jurors. As I said, you're not allowed to take pictures of the jurors, the witnesses, or for that matter, well, I don't know why I forgot, McDonald. C or D, I don't think the likelihood.
I know ultimately one of my biggest problems is Comcast, but I don't have any solution right now for Comcast.
Of the coverage distracting participants, given the fact, as I said, this is not a national news coverage. This is one individual putting it on YouTube and hoping to make money off it.
We're not monetized.
I'm sorry?
We're not monetized.
You don't get money from YouTube?
No, to get monetized, YouTube has to create a partnership with that.
Okay, so in any event, what about Facebook?
Same thing, Facebook's even harder.
You don't get hits off of that?
There are hits, but there's no payment, there's no checks.
All right, in any event, as I said, there's minimal exposure. The adequacy of the physical facilities, we're fully capable of taking care of that. I don't think F, any other factor affecting the fair administration of justice. What their motivation is does not concern me. It is, as I said, Mr. Mueller, that's a very small contingent, and the fact that people from potentially all over the country look to see a courtroom, whatever you would call it, certainly Mr. McDonald's failure to cuff up, as they say, I don't think those are grounds to exclude coverage. In addition, I want to point out, because quite frankly, my marshal pointed out, we have 65 or 75 jurors coming in, which along with the parties and other personnel puts us at the maximum for, as you can see up there, 84 occupancy. So during jury selection, we are maxed out. If you want to sit there, that's fine. You're welcome to sit in. But as far as videotaping during jury selection, it is both impractical and would impede the progression, because people are coming and going, as I said, when they're deselected, if you will, and you would be hard pressed to avoid filming individuals coming and going.
Thank you for the re-ups, new
constantly.
members. That it? Uh-oh. Hang on. Oh, we're back.
Defendant's motion to dismiss for vindictive prosecution. I had a chance.
Oh, so that was it. So he ruled that he ruled against them. They can ONJ can broadcast this. Now we're doing a motion to dismiss for vindictive prosecution. So let's see how that works.
To read it. Do you have anything to add, Mr.
Hey,
Miller?
yes, I do want to make a couple of key points. Your Honor, we as lawyers used to be trained initially as apprentices. And frequently, you would sit and work and you would study under a lawyer, and after you've seen enough cases that you got a feel for things to do, then you sit for the bar exam. That fell out of fashion because we treated it wildly unevenly trained bar, and we created law schools that then subsequently basically need to read the law anyway. So I'm not quite sure what we gained. Having said that, I bring this up because it underscores several key points about our profession, which is that it is a learned profession. You can live 100 years or 200 years or 1,000 years, and you can never see absolutely everything that could happen. You have to draw on your experiences and your observations. I saw you do it today, the last civil hearing. Now, you draw on your experiences. So, I've been doing this 25 years in this courthouse. In fact, there was probably decades went by where I didn't miss a working day in this courthouse. Now, I'm presented with a case that is extraordinary in three key aspects. Number one, Mr. McDonald is in family court. He has zero criminal record, no involvements with the law. His case of criminal in family court is going fine until his lawyer dies. His lawyer commits suicide a couple days after Mr. McDonald gives him $5,000 to continue litigation. Then he goes in front of his wife or his wife's attorney, sees an opportunity. Mr. McDonald is not longer represented and cannot afford one, and he gets hauled in front of Judge Marquis, where he requests a lawyer to represent himself. And his wife instead gets a restraining order that for the first time ever, Mr. McDonald is not allowed to see his kids. Now this is after a year of no cuts, no problems with Mr. McDonald is flabbergasted. Why can't I see my kids? He complains, and complains loudly about Judge Marquis' decision. In fact, he's so incensed by the way he's treated, he goes down and does exactly what every good citizen does. He files to run for office. He's going to run for state assembly on a campaign of reforming family court, a general common theme in the community. As a result of deciding he's going to run for office, he gets a visit from who? Not the Secretary of State's office, who's responsible for verifying this stuff. He gets a visit from the Las Vegas Metropolitan Police Department. A police officer decides to verify his residence. Extraordinary. Now we are on ground number one, unheard of. The Metropolitan Police Department getting involved with state politics. Then we go to the second extraordinary thing. The police officer, apparently, all on his own, at least he claims, decides to file a false document. Now this is extraordinary in and of itself, because this is alluded, and you've got the preliminary hearing transcript there, or here, I actually put a tab on it for you. You got the preliminary hearing transcript?
No.
This is the first preliminary hearing. This is the one that the state didn't want you to see when they dismissed the case initially. There are 750,000 documents filed every year in Las Vegas Family Justice Court, or District Court, Family Court. 750,000. Do you know how many of those were investigated for being fraudulent? One. And it was done by the Metropolitan Police Department. And then they concluded, and this is extraordinary, we did a preliminary hearing where an expert witness who had to sign off that he wasn't a threat to his kids gave him a report. Now, Mr. McDonald's lost all his money in family court because his lawyer committed suicide, so he's representing himself. So 3 days ahead of the hearing, he goes down and complies with the court order, gets the evaluation, and the doctor forgets to put the line in and says he's not a threat to his kids. So he calls the doctor, says, I need this in the line. She says, oh, get me the report back. He writes the sentence in for the doctor. That's what he does. Should have done it. Not proper form, but we're lawyers and he's not. Not substantively incorrect. So we do a preliminary hearing, and the doctor gets on the stand. The state calls the doctor, and she says, yeah, this is substantively true. I didn't write that in, McDonald did, but it's substantively true. I do not find it to be a threat to the safety of his kids. So I argued to dismiss the preliminary hearing. How can you have fraud when the statement you've made is in fact true? And I likened it to the fact of me being out of town and having someone sign my name on an urgent letter on something that comes up. It is not fraud if you write something on a document that is substantively true and later adopted by the author. That is the case that they dismissed. Then they refiled this charge to add this pettifogging theory of criminal liability, and then to underscore the nature of this case, they go into Mr. McDonald's family court file and find his financial affidavits. Now, I just been through a divorce. I didn't even look at the damn document. Sorry, I shouldn't swear. I didn't even look at the document. My lawyer said, sign this. I did. Now, we are sitting here, and we're going to do a week-long jury trial on whether Mr. McDonald spent $50 a month on food, and whether he was actually working that week or the week that he wasn't working, and if that statement is true, in family court. Now, he's not charged with a misdemeanor filing a false statement. He's not charged with anything that makes any sense. He's charged with numerous major Class B felonies. Now, the soul of vindictive prosecution, it's very clear. Nevada makes it abundantly clear. It's a bright line litmus test. If somebody takes actions or the state takes retribution for lawful actions.
Thank you for the prime sub. Quiet.
Prosecution. Now, he's antagonized Judge Marquis. There's absolutely no doubt about that. He has represented himself in family court, and every time he goes to family court, Judge Marquis takes the screws to him, takes his kids away further, and by some mechanism, whether it's through his ex-wife's connections to the Metropolitan Police Department, or whether Judge Marquis picked up the phone, we have an ever-spiraling escalation of pettifogging, never seen before in my life, theory of criminal liability. And all after, make sure you understand this, all after he had the temerity to criticize a public official and go down and run for office. And when that Metropolitan Police Department detective gets on the witness stand, he'll ask him, you investigated any other candidates? You go through anybody else's personal files at home to see if their family court filings are in order? Now, my colleagues know how strongly I feel, and you can hear how strongly I feel about this case. Let her stand up and in her experience, or her colleagues' experience, or for that matter, anybody in the district attorney's office in the last 30 years can point to one case that is within 1,000 miles of this prosecution, and I'll shut up and we'll do the trial. This is vindictive use of the government authority. This is not, hey, we got a problem with drugs, let's go out and get drug dealers. This isn't a problem we got with the problem with drug driving. This is, let's screw Michael McDonald because we don't like him. And that's all this is. This case should not go forward. This case should be summarily dismissed. And Ms. Mishler should stand up with a straight face and describe any other case that she's handled remotely like this one. Thank you, Your Honor.
Steve?
Your Honor. I find it interesting that defense counsel started by stating that legal decisions must be made through our observations and experiences, which can sometimes be relevant, but obviously, as the court knows, legal decisions are based upon precedent and case law and statutes, not based on defense counsel's personal experience as an attorney, regardless of however long that may have been. So I want to first address procedural irregularities and inappropriateness of the filing of this motion, and then I'll hopefully briefly
here we go.
discuss the merits of the motion itself, but largely I addressed that back in November when defense counsel initially filed the same motion. So first of all, this motion is clearly untimely. If this motion that defense counsel filed yesterday is not considered untimely, then the word has ceased to have any meaning at all. Pursuant to 8th Judicial District Court Rule 3.20 in criminal cases, all motions must be served and filed no less than 15 days before the date set for trial. This motion was filed while we were selecting a jury for this trial. It's clearly untimely. There are other rules regarding things like motions in limine and discovery motions, and this motion is clearly not one of those. So this was untimely and should be denied simply on that basis. Further, it's essentially the other procedural irregularity is this motion would have been more accurately titled a motion for reconsideration, because this really is the same motion that was filed by defense counsel on November 5th of 2018. And defense counsel has not explained why after Your Honor denied that motion, he didn't simply file a motion for reconsideration sometime in the past 10 months. I didn't hear any explanation as to why this motion was filed while we were selecting a jury for this trial. Additionally, a number of the arguments made are essentially arguments that would typically be made in a petition for writ habeas corpus, though obviously the deadline for filing such a writ has long passed. And it really is essentially the exact same motion. You'll notice I compared the motion with the one that was filed on November 5th. The section on the current motion that was filed on September 4th, yesterday, though entirely devoid of legal analysis, the section that says analysis is substantively almost word for word the same as the analysis section of the motion that was filed on November of 2018 by defense counsel. Essentially, that motion was double jeopardy and vindictive prosecution. There's been some editing to remove the double jeopardy argument, but it's essentially the same motion. It's a successive motion and should be denied on that basis. Additionally, so now I find myself in the position of making the exact same arguments that I made when we argued this same motion about 10 months ago. Once again, the defense counsel has established that he completely misapprehends the entire concept of vindictive prosecution. He did not state any case law that is remotely similar to this case and remotely establishes any basis for dismissal of this case, especially while we just selected a jury for trial. The defendant's motion cites Jenkins and it cites DeMarco and doesn't establish how those cases have any remotely similar facts. In the case of Jenkins, the defendant was arrested in a car in which a large amount of marijuana was found, as well as illegal aliens. The defendant in that case admitted to law enforcement that she had been transporting illegal aliens. She knew nothing about the drugs in the car. She was then prosecuted on drug charges. She took the stand in her defense and testified that she knew nothing about the drugs in the car, and all she thought she was doing was transporting illegal aliens across the border. Then, while the jury was deliberating in that case, then for the first time the state filed charges charging her with human trafficking of illegal aliens for the first time, essentially covering their bases and essentially penalizing the defendant for taking the stand in her own defense, which is a constitutional right. Nothing of that kind has occurred here, and defense counsel's entire argument is based on, at least in the motion, is based on the activities of law enforcement, stating that the entire reason for this prosecution was simply the fact that he was running for office, which is simply not true. Additionally, that's not that's even related to the case law regarding vindictiveness. The state doesn't have to establish the reason for the prosecution, and this court doesn't actually have jurisdiction to evaluate the behavior of the police unless there's been an issue raised regarding the Fourth or Fifth Amendment, and that's not what's going on here. In none of the cases regarding vindictiveness, either prosecutorial vindictiveness or judicial vindictiveness, in none of those cases did the court ever hold that the initiation of the initial prosecution itself was improper. I reviewed all of this case law. In none of these cases, the U.S. Supreme Court or the Ninth Circuit or any of the other federal courts, none of them ever held that the state should not have been prosecuting this defendant at all. They just held there was some sort of procedural irregularity in which the defendant was penalized for exercising her right to testify at trial, or for exercising an appellate right, or for exercising the right to a change of venue, which exists in the federal system, something along those lines. At none of these cases did the court conclude, oh, well, this person should not have been prosecuted. And I think the argument needs to be put to rest that the fact that this is somehow an unusual case means that this case must be dismissed. I didn't hear defense counsel cite one case that stated that the state must establish that a defendant has been previously prosecuted for similar conduct in order for a case to proceed. Criminals every day are thinking of new ways to commit crimes. Additionally, there is nothing in the forgery or perjury statutes that requires that essentially means that a defendant cannot be prosecuted for those crimes if they occur in family court. There's no special inoculation for the fact that something occurs in family court. A person can still commit crimes by filing a forged document. And
True.
I find it strange that defense counsel seems so confident that nothing of this nature has been prosecuted before. I've been on the fraud unit at the DA's office a mere 2 years, and without much effort, I can think of two similar cases. One, the case involving April Parks and numerous other defendants, which was based upon numerous fraud as well as theft involving guardianship cases. And as we all know, guardianship cases are part of family court. And all of those defendants have been, all of those cases except for one of the defendants, those have been closed. The defendants took guilty. April Parks is in prison now for actions she took in relation to family court. And the sole remaining defendant is set to go to trial next week in front of Judge Tara Jones. Additionally, James Vega, I myself recently charged an individual with numerous crimes and had a criminal complaint filed based on what was initially being investigated in this case. There's a gross misdemeanor charge in the Nevada statutes called false candidacy, essentially called false residence for candidacy. There are certain documents that a candidate must file when they run for office, and they must list their address and establish that they live in the appropriate district for which they're seeking office. James Vega is currently charged with violating that crime as well as forgery and other crimes stemming from that incident. But again, I hope Your Honor doesn't take the fact that I pointed that out as somehow capitulating that we have to establish that the state has prosecuted similar crimes like this in the past. That's simply not a requirement. I didn't hear any case law being cited that supports that idea. Quite frankly, this is a frivolous motion. It's virtually identical.
So she is calling out his attorney really bad. Basically saying, like, just because this is a rarely prosecuted crime doesn't mean it can't ever be prosecuted. Number one. Number two, the fact that they refiled new charges against him, is not really evidence of anything. They're allowed to do that. And she was basically calling him out.
That was filed by defense counsel approximately 10 months ago that Your Honor denied, and now it's being refiled. This is the most untimely motion I think I've ever seen. And while I may not have practiced as long as defense counsel, I've been barred about 5 years. I've never seen something this untimely, and there's no reason for it. There's absolutely no reason that the defense counsel couldn't have filed a motion for reconsideration 9 or 10 months ago. And yesterday, when I brought this up, the fact that the motion was successive, defense counsel stated, well, the state has changed its theory of liability since I filed that motion, which one is not true, and defense counsel knows that, because we're proceeding off the original indictment that was filed in October, prior to the defense counsel filing that motion. Additionally, nothing in the motion or his argument deals with the state's theory of liability in the first place. So, defense counsel, quite frankly, is violating the rules of
full of it.
conduct. I mean, he's in violation of 3.1 because 3.1 requires only the bringing of meritorious claims. This is a frivolous motion. The rule states a lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless there is a basis in law and fact for doing so. There is no basis in law or fact for bringing this motion, and defense counsel's personal experience practicing in this jurisdiction is not a basis for this motion. Additionally, he's violating Rule 3.3, which requires candor to the tribunal. He basically lied to Your Honor yesterday. Further, Rule 7.60 of the 8th Judicial District Court states that sanctions may be imposed when counsel presents to the court a motion which is obviously frivolous, unnecessary, or unwarranted. This motion is all of those things, and I request that Your Honor impose sanctions against defense counsel. Thank you.
Oh, damn! Call for sanctions!
One case where a proper litigant was pulled into court for a false filing.
All right, counsel, let's address what I want to know, and that is untimeliness, and this is a motion for reconsideration.
Right, Judge.
You can call it what you want, but it's 6 months after the original, it's untimely.
The original, respectfully, my colleague doesn't remember the procedural history of this. I filed a motion to dismiss on procedural history because they went forward on a factually correct filing. They didn't dismiss and brought 2 additional theories of liability that his financial disclosures weren't accurate. Now, she cannot, has not, and will not be able to stand up and tell you that any other pro per litigant has ever been held to account on felonies. She mentions 2 fraud and theft cases. That's not this case. Now, this is a man who ran for office, and after he filed for office, he was charged with a crime. I have a moral and ethical obligation to make every opportunity for the judge to the court to do the right thing here. Now, this is not anywhere near a civil case. This is a criminal case. He is wrapped with the Constitution and constitutional rights. Now, this is retribution for criticizing a judge and for running for office, pure and simple. This is political vindictive prosecution. It's not selective enforcement. She didn't stand up here and say, yeah, let me tell you about the other guy whose lawyer killed himself and was prosecuted for filing false documents. That didn't happen. All these documents here are pro se litigation documents. Now, I see an enormous difference here between what she's talking about and what she's trying to do. Now, 750,000 documents get filed a year down there. Who gets prosecuted? One guy.
Oh my God, what a Weasley.
A fraud detective? No, it's a Metro detective. Now, Your Honor, this is vindictive prosecution through and through. And yes, I have a moral obligation and legal obligation to make sure that the record is correct here and you understand exactly what's happening. Now, this is not correct. It's appropriate, and under criminal law, I can stand up at any time appropriate with the quorum of the court and make a record of what needs to be done. I've drawn the court's attention to the law. It's in the motion. I've drawn the court's attention to the fact. I've drawn the court's attention to the extraordinary procedure I have in Wiley's here. I've also drawn, and she's underscored, the fact that there's no other case anywhere in the system like this one. And I don't understand how we don't reach the simple conclusion that this is vindictive prosecution.
All right, thank you.
My God.
I'm denying your motion on numerous grounds. First of all, it's
Denied.
untimely. There is nothing that has changed in the last, let's say, 2 months that would have precluded you from filing this motion on a timely basis. To file it in the midst of selecting a jury, a substantially similar grounds to a prior motion. You're right, it's not exactly the same. I grant you that. But this could have been filed 2 months ago easily, if not before that, or certainly 30 days ago. Nothing has changed here that would have prevented you from filing this in a timely manner. Second of all, I do consider it, even though it isn't identical, it is substantially similar to the prior motion, and therefore it should have been a timely motion for reconsideration. The arguments made are the same arguments that were made back then regarding the fact that the defendant was the only one.
So not only is it grossly untimely, it is also improperly filed.
Who's been prosecuted under these similar circumstances. But again, the next grounds for denying it, the fact that no cases are identical or this hasn't been done doesn't mean it shouldn't be done. Your argument, which seems to be that people do fraudulent things in family court all the time, and they're for some reason picking on my client, and quite frankly, that is not grounds. They should all be following the law. And if the state in this case, and I use not this particular case, but if the state decides they need to enforce, I hate to use an old word, shenanigans that do take place every day, allegedly take place every day in family court, then that is appropriate, both for basically showing that it shouldn't and can't be done if in fact it is illegal, and if in fact, in this case, Mr. McDonald did and carried out what is alleged, then he violated the law. The cases you cited, the only two cases, are nowhere near what we have here, and you argue that this is somehow judicially driven by the family court judge. Not, again, that is not your allegation in the written pleadings, that this was done because he ran for office. So your statements today belie your claim regarding Jenkins' case, that this was done because he ran for office. Now you said it's because he made allegations and by the way, I think both parties seem to think I have a knowledge of all the facts in the family court case, which I do not. Judge,
as he shouldn't, for purposes of fairness,
because apparently she was part of proceedings down or over in family court. But in any event, as far as the actual grounds, if you will, under the federal cases, they don't apply here. In addition, as the last comment, I find no good cause for the delay in filing this. As I said previously, there was plenty of time in the last, we've met several times on several issues in the last couple months prior to yesterday, and so there's absolutely no good cause for the extensive delay. I'm not going to order sanctions. I think they're reserved for the most egregious of actions, although this is delayed and it has cost us a half hour or 20 minutes before bringing the jury in. As I said, I'm not going to award sanctions. That's it. The state will have to prepare.
No sanctions, though.
Yes, Your Honor.
Anything else before, and by the way, we're going to take a couple minute break since I've been going. We've been here for well over an hour. You weren't, but we have. And then we'll bring him in unless there's anything else. State.
Not from the state, Your Honor.
Defense.
No, Your Honor.
Okay, we'll take about 2 or 3 minutes.
Oh God. All right, hold on. Let me fast forward this.
And the lies he chose
We're going to opening statements now.
Unfortunately, ladies and gentlemen, the corners that he chose to cut.
Hang on. I don't want to skip. All right, here we go. I thought I did make you a mod, Mandy. Uh-oh.
Main City come to order, public 28th game session.
Okay, ready to go?
Yes, sir.
Yes, sir.
Please be seated. Okay, state opening statements.
Thank you, Your Honor. This, can you hear me?
There we go.
Test. 1, 2, thanks. Michael McDonald was going to get what he wanted, no matter what it took. No matter what corners had to be cut, no matter what lies had to be told.
Objection, is there any evidence in this case?
Well, my words are
Oh my God, really?
He's directed for what the evidence is going to show, not his opinion.
Unfortunately, ladies and gentlemen, the corners that he chose to cut.
Not even like a sentence into his freaking opening statement, he gets an objection.
The lies he chose to tell, specifically where and how
Your
those
Honor,
lies
I'd
were
ask that
told.
a continuing objection to this opening statement be lodged. Does not
Make
take
sure
reference
you
to the
address
evidence.
what the facts will show.
Ladies and gentlemen, the evidence will show that those corners that he chose to cut and the lies he chose to tell, specifically how they were told and where they were told, constitute felony criminal offenses. In the next couple of days, you'll hear from various witnesses during trial. One of them is a detective with the Las Vegas Metropolitan Police Department, Detective Aaron Stanton. Now, Detective Aaron Stanton is assigned to a specialized unit called the Criminal Intelligence Section. And what he and his unit do is probably a little different from what you might expect from police officers and detectives. They work generally with public integrity cases, which involves allegations and investigations about political corruption, specifically politicians or candidates who are running for political office, or other professionally licensed individuals like physicians, lawyers, judges, or other law enforcement officers. As part of that, what they do, among other things, is they monitor certain websites on the internet where allegations are commonly made in disdain. Politicians, other licensed individuals, and they follow up on those leads to determine if there's merit to those allegations. And that is where this case begins. In March of 2018, Detective Stanton observed some comments on one of those websites in regards to the defendant, Michael McDonald, who was at that time running for political office. Specifically, the allegation revolved around a residency violation. Somebody alleged that he didn't live within the district in which he was running. Based on that, an investigation was opened by the detective. The very next day, on March 20th, Detective Stanton found some additional allegations on another website. And these were about alleged forgeries in a family court case that the defendant was at that time involved in. Based on that, an investigation was furthered, and the detective found out that the defendant was at that time in a divorce proceeding with his now ex-wife, Candace, and that they had a family court case in which the defendant was representing himself, meaning he was acting as his own counsel. Litigation was still ongoing at that time, specifically revolving around child custody issues, and that family court case was assigned to Judge Linda Markey in family court. The evidence will show, and you'll hear from various people, you'll see various documents. We'll try to make clear what those documents mean, and eventually you'll have those documents and evidence to hold and look over for yourself. But the evidence will show that on September 27th, 2017, the defendant filed a motion in his family court case. This is the first page of that document. You can see in the top left corner the defendant's name and that he is in.
Objection. Why don't we show looking at evidence? It has been authenticated, hasn't been
Counsel
admitted.
approach.
Briefly, GS Galloway that says on Kick, how do I subscribe or become a member? Right now, I'm not eligible for subscriptions on Kick. I need to have a minimum of 75 followers on Kick. So that's why I'm kind of pressing it, and that's why you see the meter on the top left of the stream.
Sustaining the objection.
And eventually, you will be able to see these documents for yourself. On September 27th,
Hey, Big N, welcome.
filed a motion in family court in his divorce proceeding case.
Welcome, Big N Raiders.
Attached to that motion was a document that will become very important in these proceedings. It was a letter from the defendant's therapist, Nancy Hunterson, marriage family therapist. The letter described what she was meeting with the defendant for, that they were talking about issues.
No worries, Galloway.
Children, and that she had been seeing him since June 2017. That was attached as an exhibit. December 4th, a couple weeks later, 2017, the defendant files another motion, and attached as an exhibit is that same letter. But this time, the letter has one key difference, and there has been a sentence added.
Welcome, Big N Raiders. Please hit that like button. Also, I am simultaneously streaming on both Kick and Twitch, along with YouTube. I'm working to get 75 followers on Kick, if I'm able to, so I can invite people to subscribe there. The reason I like it is because Kick takes, I get 95% of the revenue from Kick subscriptions compared to just like 70% from YouTube. But I need 75 followers on there. It's another live streaming platform, just like YouTube has live streaming in anyway. Also, Sathail, thank you for the gifted Twitch sub. Much appreciated, man. I really thank you so much, man. Sathail, you've been way too generous to me today. Actually, over the weekend, you are crazy. But thank you so much, and thank you for the $1.99 super chat, Candace.
To the bottom of that letter, it says, "I do not believe Mr. McDonald is a harm to his children or himself."
Wait, is that actually Candace? Oh my. I don't know, but if you are, thank you so much. I hope you're doing well. All right, moving on.
A couple weeks later, December 20th, 2017, the defendant files another motion in that same case. The original unaltered letter is attached as an exhibit without the added sentence. A couple months later, in March of 2018, a hearing has been scheduled for the 16th, and it's based upon kind of the litigation ongoing, some of the motions that have been filed. And in preparation for that hearing, the defendant files an exhibit list, which is filed in its official court document. Part of that exhibit list is, again, the letter from the therapist. This time it is the altered or forged version, and it includes the sentence at the bottom. "I do not believe Mr. McDonald is a harm to his children or himself." On that same day, and within that same packet, the defendant files a general financial disclosure form, wherein he kind of outlines what he does for a living, how much he makes. He says in that document, or that list of documents, that he has no income other than $800 a month from odd jobs. He lists his last employer as Geotab, which he says ended in February of 2017, over a year ago. And he also states that he does not have a current employer. And that
Welcome,
is
everybody.
filed as an official document. 3 days later, the hearing goes on as planned, and the defendant is sworn in under the penalty of perjury. You'll see a video where he does that, promises to tell the truth. During that hearing, he testifies again that he makes $800 a month from odd jobs. He also testifies that he filed the exhibit packet, including the financial disclosure form, which was spoken about in the previous slide. On March 21st, 2018, the Detective Stanton, based on his investigation, meets with the therapist, Ms. Hunterton. And he asks her about these two different letters. He shows her the forged letter and asks her if she recognizes it. She compares that letter to the letter that she had prepared and is still in her personal file for her client, for the defendant. And she recognizes to the defendant that she knows
Thank you, Candace, for the $1.99 again.
27 and December 20th. But she says she does not recognize the forged letter, or the letter with the...
So Thale asks on Twitch, Candace Ruiz, who sent me the super sticker, I'm assuming that's her. She is the ex-partner of Mr. Michael McDonald. She has long since remarried, and I hope she's doing much, much better these days.
Added sentence that was filed on March 13th, 2018. Also, on March 21st, that same day, the defendant files another motion. And in that motion, attached as an exhibit, is the forged therapist letter, the third time it has been filed in a court document. On April 11th, based upon the investigation by the detective, he obtains a search warrant for the defendant's residence. They go to his residence, they speak with the defendant, they talk to him specifically, obviously, about the forged letter. And the defendant makes excuses about how the wording should have been there anyway, and that my therapist would have allowed it. The defendant would not, however, admit to having actually added the sentence. The defendant voluntarily shows the police his Google Drive, which includes obviously all his paperwork. Within that drive, there are copies of the original letter as well as the forged letter. They also search his car, which is parked out front. Inside is a binder with all his litigation paper, all the exhibits, all the motions he had filed, and among those is the forged letter. During that search warrant and the conversation that the detective has with the defendant, eventually the detective offers, maybe we should call Ms. Hunterton and ask her, because you're alleging that she would have written this or she gave you permission. So they call her on the phone, on speakerphone, with all three of them present. And she says that the original letter came from her office. He said the altered letter did not. She says she never gave the defendant permission to alter that letter. And she says that there was at one time communication with the defendant about possibly writing an additional letter in the future, which never happened.
Well,
after the search warrant, on April 19th, 2018, this is about a week after the search warrant happens, the defendant goes to Ms. Hunterton, his therapist, and asks her to prepare an affidavit, which she does. In her affidavit, she states that, yes, I wrote the original letter. She states that she would have written the letter with the sentiment about the defendant not being a danger to his children if she were given the opportunity. That same month, in late April of 2018, Detective Stanton finds something else very important. He discovers that the defendant has current employment at a place called Progistics. He finds out further that the defendant has worked there since October 23rd, 2017, that he makes approximately, as a salaried employee, $47,500 working in the IT department, and that as of April 30th, he was still working there. There was no lapse in his employment between the October 2017 and April, while he was put under oath and said that he was unemployed. This all falls within that spectrum when he was full-time employed. His net take-home pay every 2 weeks is over $1,800, which means he makes approximately...
So now they're moving on from the forged doctor's or therapist note to his financial disclosure form.
$3,600 a month. You will hear from additional witnesses in this case. You'll hear from Christine O'Connor, who works for the 8th Judicial District Court Clerk's Office in regards to some of the filings that you will see later. You'll hear from Nancy Hunterton, the therapist that was mentioned. You'll hear from Brett Zagaski and Timothy Spees, who are both marshals who work in the courthouses. You'll hear from Lisa Smith, who works in the HR department at Progistics, where she dealt with and spoke with the defendant on a daily basis while he was employed there. You'll then hear from Detective Stanton, who I mentioned is the lead investigator on this case. And finally, you'll hear from Marshall Willick, who is an expert in family law. After you have heard from these people, and you have seen the evidence and heard the evidence, you will come to the obvious conclusion that the defendant is guilty on all counts, which include multiple counts of burglary, forgery, perjury, and offering false instrument for filing or record. Thank you.
Ladies and gentlemen of the jury, Mr. McDonald hasn't done a thing wrong. Detective Stanton is what you would call, and the evidence will show, what you call is a politically correct enforcement division of the Sheriff's Department. Mr. McDonald is getting divorced. That's unfortunate. Most of you were asked about during jury selection if he'd been through a tough divorce. Mr. McDonald's divorce is going just fine, such as things go. His attorney, God rest his soul, received about a $5,000 retainer from Mr. McDonald, and then, for whatever reasons known only to him and God, committed suicide, leaving Mr. McDonald without money and without an attorney. $5,000 gone. Mr. McDonald has no attorney, and he now has to represent himself. And I asked, and you'll hear, about having to represent yourself in a lawsuit. he's now got to represent himself. His wife, ex-wife, uses that opportunity for Mr. McDonald, who doesn't have an attorney now, to file a restraining order and to take away the kids. Mr. McDonald has no attorney and no money and has to go in and represent himself. And Judge Markey sees fit to take away his custody visitation. No contact with your kids because your ex-wife said no. No lawyer, no money, no attorney, no kids. Not surprisingly, he's not particularly happy with that outcome. He complains about it. He decides that he's going to run.
He complains about it. That's one way of putting it, I guess, given what we've already seen.
For office on the platform of reforming family court based on the treatment that Mr. McDonald has received at the hands of family court. Knock on the door, in shows the state's police. Your papers, please. We want to see, based on an anonymous report on a website called Nevada Court Watchers, Detective Stanton gets an anonymous tip. So he goes over and knocks on Mr. McDonald's door to find out if he actually lives at the location. He isn't from the Secretary of State who runs the elections. He's not from the quarters office. A local county sheriff in the political crimes unit, Detective Stanton, goes into Mr. McDonald's house to verify he lives there, based on an anonymous tip. So when he finds out that Mr. McDonald does in fact live at the address he's registered to run for office at, that's not good enough. It's political crime season. We're going to find something wrong. So then they go in and they start going through Mr. McDonald's pro se. He's pro se doing complex civil litigation. And they start combing through dozens, if not hundreds of pages to find something wrong. Something wrong. And what did they come up with? 3 days before a report was due, Mr. McDonald went and met with the family therapist. She didn't put in the exact language that was needed, which is specifically that he's not a threat to his kids. He calls her up. She says, oh, okay. So, not being an attorney, he writes it in and turns it in. And what she was going to testify to, what she's previously testified to is, yeah, what's in this report is correct. I didn't write it, but I agree with it. So there's no forgery. You don't have a crime. There's no intent to deceive. That's the evidence. So, when that case comes out, then Mr. McDonald, now without a lawyer and without any money and without his kids now going on 3.5 years, files his financial affidavits. They file them in October or September, and the hearing gets kicked to March. And as you heard from my colleague, the documents, when filed, were in fact correct. Ladies and gentlemen of the jury, what you're going to see here is the most blatant exercise and abuse of police powers that you can imagine in the United States. A citizen goes down and files for office, and his reward is a county sheriff doing a search warrant on his house based on an anonymous tip on a court-following website. And you're going to hear from Mr. Willett, a primary participant in that website, and it's a website where all the family court lawyers and judges talk to each other anonymously. And you're also going to hear that it was actually shut down because it was interfering with the good order of justice in the family court. Now, there's a reason you're here, ladies and gentlemen. The reason is you're going to need to vindicate the legal system and protect them, and protect Mr. McDonald from politically correct, picayune, dishonest, intellectually dishonest enforcement of law. The evidence is going to show he's not guilty on every count.
Using them SAT words. Picayune.
Nothing wrong here. This is the governmental establishment upset with someone who had the temerity to run for office and to complain about how he was treated by a family court judge. And that is why you are here. When you listen to those documents, you watch those and you think about yourself. Hey, I need a lawyer. Yeah, you do.
Thanks, Mark.
Where was he?
For the 11 months.
Dead. What happened? He's got my $5,000. I've got no lawyer. And now Mr. McDonald is sitting here, and you need to find him not guilty, and the evidence will support a finding of not guilty on every charge.
Thank you.
Well, with that out of the way, I want to note, guys, that it looks like Hey, Damien, I do see you and Kick. Does look like that is the actual Candace, and she asked if I could share the link to her GoFundMe. I don't know if you guys are aware. I believe Mr. McDonald is out of prison now. I mean, spoiler alert, he does get found guilty on at least one or if not all of the charges. But I think as of now, he's out of prison, and he's still making things difficult for Candace. And so she does have a GoFundMe for her legal defense. And Mandy just posted in the YouTube chat. So if you want, you could send what amount you want to help her out. So. You're getting things that are happening on your phone app. Yeah, guys, again, if you guys are having issues on YouTube's been having some difficulties all weekend. Hence the reason why I've been plugging my Twitch and Kick live streams just in case. You guys can check it out. It looks like Kick is running a lot better than YouTube at the moment. So go ahead and check it out if you want to.
State, call your first witness.
Can we have the pulpit turned here? Your Honor, while he's doing that, before we call our first witness, the state would move to admit Exhibit 1, which are certified court minutes from the hearing from March 16, 2018. They've been authenticated and certified, and we would move to admit them under NRS 52.125.
Can I see them, please?
Move to
I object. There's this exhibit that.
All right, the objection is withdrawn. The document will be admitted. What was
Exhibit 1, Your Honor.
Exhibit 1?
The state calls Christina O'Connor.
You just solemnly affirm the testimony about this action shall be the truth, the whole truth, and nothing but the truth, under the case of no perjury. Thank you. Please be seated. And will you please state and spell your first and last name for the record?
It's Christina O'Connor, Kristina, O''C-O''N''E-R.
Go ahead.
Good morning, Ms. O'Connor. Can you tell the members of the jury what you do for a living?
I'm the Court Division Administrator for the Family Court Clerk's Office.
Is that in the 8th Judicial District Court Family Division?
Yes, it is.
Where's the family court located?
At 601 North Pecos?
Is that in Clark County, Los Angeles, Nevada?
Yes.
Well, Court Division Administrator, how long have you been in that position?
I've been in that position just over 7 years.
And if you can, tell us what some of your duties are in that position.
I oversee the entire Family Court Clerk's Office, which includes our customer service windows, the court clerks, our e-filing units, at that time, also the records divisions, child support, any other clerical duties.
How many court clerks are employed at the family court building?
Just court clerks or court clerk staff, meaning, because they're all titled court
Okay,
clerks
so
per se.
how many specific court clerks?
I don't know the actual court clerk number off the top of my head.
Okay, approximately how many employees then do you oversee?
I oversee approximately 103.
103?
Yes.
And just to kind of clarify what you listed as your duties, as part of your job, do you regularly review court filings and court documents and court records that people file in that building?
Yes.
Specifically in family court cases, is that correct?
Correct.
So, if I can, I'm going to ask you some questions about the process of filing court documents, okay? Can you walk us through how a person files a court document?
There are a couple of ways to file currently. You can either electronically file them through our File and Serve program, or you can also come into either of the locations of the clerk's office at both Family Court or the RJC and file documents across the counter.
When you say RJC, is that the Regional Justice Center?
Yes.
Are we currently standing in the Regional Justice Center?
Yes.
Okay. Is that at 200 Lewis Avenue, Clark County, Los Angeles, Nevada?
Yes.
Okay. So people can file family court documents here in this courthouse, is that correct?
Correct.
Okay. You also said you can do it in person, here at family court, but you also said electronic filing. Where does that take place?
You can either electronically file from an outside area, you register for an account, or you can also use kiosks that are located in our lobby at the Family Court location.
And who can do that? Who can file something? Is there any limitations?
No.
Let me ask you this. When you file a document which would be considered the original, who keeps the original?
The original is through the customer service counter, can I?
Yes, if you in person, yes.
If it's through the counter, the filer keeps the original, and we scan that into the system.
Okay. If, for whatever reason, they lose that original or just need another copy that is certified or authentic, and can be used in a court proceeding, how does somebody certify a copy as to use in court?
They would come to our customer service counters, do a records request,
Okay.
and then request a certified copy from the record, and then pay any required fees.
And what goes into assuring that it's a certified copy? What is that process like?
I need you to clarify that a little bit, sorry.
Do they compare it to another document, or do they stamp it? How does that process work?
If the customer doesn't have a copy of it, we print the copy out of the case management system, and then we certify that document directly out of the case management system.
And when you say we certify, what do you physically do to certify a document?
The clerk knows at the counter that they printed it directly out of the system, so then they will take any required filing fees that are for that. They stamp it with our certification stamp, and they get embossed, and then I believe they sign their name, but I would need to double check.
When you say embossed, does that mean there's a kind of a raised insignia?
Usually.
Okay. And when you mentioned file stamping, where on the document is a file stamp located?
For when the document's filed?
Yes.
It's up in the upper right-hand corner.
And what information is included in the file stamp?
It would be the date, in some cases the time. It states it was electronically filed. It has the clerk of court's name on it. I believe that's it from off the top of my head, not seeing one.
So you said the date, and then you said sometimes the time. Why would it not include the time?
It depends on how it gets filed. So currently, the way our system's set, that is if a document gets electronically filed through our file and serve program, then it will include the time that it was submitted into it. If a document is coming across our counter, it does not have the time associated on that file stamp.
Okay. So if somebody does it at a kiosk in the lobby, it'll have the time stamp.
Correct.
Okay. Or if they do it from another location that has been permitted to do that.
Correct.
Okay. Are there, in various rooms, the courtrooms at the Family Justice Center, or the Family Court Center, is there a video surveillance?
In
In the family court hearing rooms, down at the family center?
do you mean the JAS system?
Okay.
Which records the hearings?
Okay, so when you say JAVS, what is JAVS?
It's the Jefferson Audio Visual System. It actually records hearings.
Okay, and audio and visual?
Yes.
Okay. We've been referring to the family court. Is it sometimes referred to as properly Family Courts and Services Center?
That is the location, yes.
Okay. Brief indulgence. Do you also, we've talked about court documents and proceedings, do you also review and certify court minutes as a part of your job sometimes?
My staff do, yes.
Okay. Can you explain what are court minutes?
Court minutes are a summary of what occurred during that hearing.
Okay. So it would include the date and time, the parties present, and what occurred during the hearing? Permission to approach here? Just a... Joint Defense Counsel, Your Honor, the state's proposed exhibits, I believe it's 2 through 7. 2 through 6, thank you.
What exhibit number is that?
I've taken all of them. I'll put it on the record as I approach, Your Honor. May I approach? Thank you. Okay, Ms. O'Connor. I'm showing you a court exhibit Court exhibit number 2, pardon me, court exhibit number 1. What does that appear to be?
It appears to be a certified copy of a document that was filed on September 27th of 2017.
When you say certified, so I can flip it back to the, does it have the emboss on the back page?
It does, yes.
Okay. Showing you proposed exhibit 2. Showing you proposed exhibit number 2, what is that?
It appears to be a redacted copy with a similar appears to be a redacted copy of it.
When you say redacted, there appears to be a lot of black on those
Correct.
pages. So does it appear to be a redacted version of the certified copy on the left?
It does, however, the redacted copy has the time associated in the file stamp and not on the copies that was certified in 2018.
Is the date the same?
The date is the same. Yes.
Okay. And the parties and the title to the document, are those all the same? It's a lengthy title, sorry.
No, that- Yes, they appear to.
The state would move to admit state's proposed number 2.
That would be the redacted copy?
Yes.
Okay.
Will be admitted.
Showing you court exhibit number 2, as well as state's proposed 3. The same question, the court exhibit, what does that appear to be?
A certified copy of a document that was filed on December 4th of 2017.
And is state's proposed 3, does that appear to be a fair and accurate copy, but with the majority of the document redacted?
Yes.
Move to admit state's proposed 3, Your Honor.
No objection.
Will be admitted.
And for the record, that is the redacted copy.
Yes.
Okay, ready to go.
Showing you court's exhibit number 3. What does that appear to be?
A certified document that was filed on December 20th of 2017.
And showing you state's proposed exhibit 4, does that appear to be a redacted version of the same?
Yes.
The state would move to admit the redacted version, which is state's proposed exhibit 4.
Objection.
No objection.
Will be admitted.
Showing you court's exhibit 4, what is that?
It's a certified copy of a document that was filed on March 13th of 2018.
And showing you proposed exhibit 5, does that appear to be a redacted copy of the same?
Yes.
State moves to admit the redacted version, which is state's proposed exhibit 5.
No objection.
No objection to the redacted copy.
Will be admitted.
And finally, showing you exhibit 5, what does that appear to be?
A file stamped certified copy of a document filed on March 21st of 2018.
And showing you state's proposed exhibit 6, does that appear to be a fair and accurate copy of the same, but with the majority of the document redacted?
Yes.
The state would move to admit the redacted copy, which is the state's proposed exhibit 6.
Any objection?
No objection.
Will be admitted.
Jump back to the pulpit.
You-
Sorry. Thank you.
All right. Y'all can't hear me, can you? Or you can hear me now? Okay.
Permission to publish exhibit 3, Your Honor?
Go ahead.
So what we're looking at is what's been previously admitted as state's exhibit 3. You can see on the bottom the redactions. We talked earlier, Ms. O'Connor, about file stamps. Can you describe to us where on this document the file stamp is?
In the upper right-hand corner.
Okay. And you can actually use your mouse there in front of you, I think. Does that give you a little bit of... Okay. So you're pointing to the top right of the document, where it says electronically filed, is that correct?
Correct.
And what is the date on that?
December 4th of 2017.
And the top left, who is the party filing that document?
It's listed as Michael McDonald.
And I know you described this earlier, but when it says electronically filed, what does that tell you?
Both of our file stamps will stay.
Okay, guys, I either I don't know what's going on, but I think what I'm gonna end up doing here is instead of streaming on all 3 platforms at once, what I'm going to stream on YouTube and Kick, and then like on Tuesday or Wednesday I'll stream on YouTube and Twitch, and kind of alternate between that to see how it works and see if I can get it working right. Because yeah, I apologize to how bad things are going right now. I'm really sorry. I really hate Comcast, but hopefully these things I can figure out isolate what the issue is. All right.
Electronically filed.
Okay.
Because that's how they get entered into the system.
But the fact that this doesn't have a time also next to the date, what does that tell us?
That tells me that it indicates that it came across one of our customer service counters.
Publishing states Exhibit 2. You can also see here that we've talked about the redactions there on the bottom. This is the front page. What does the file stamp there tell us about this document?
That it was filed on
Thanks,
September
Tiki.
27th, 2017 at 8:02 a.m.
And who is the party filing this motion?
It's listed as Michael McDonald.
Pretty indulgent.
Okay.
Republishing states Exhibit 3, which has been previously admitted. Did you review documents associated to and records associated to this document to determine
All right,
where
let me-
it was filed?
All right. I appreciate all you guys. I do appreciate you guys on Twitch, and I appreciate you guys on Twitch and Kick. What I'm gonna do is I'm gonna stop the live streams on both of those and see whether or not that fixes YouTube, and as a first test. But I really do appreciate you guys coming in. I'm only gonna be streaming for maybe another half hour anyway. But I want to kind of test this out and see if it really is the multi-streaming that's causing the issue. So I'm going to stop the stream on Twitch and Kick and see if that fixes things. So if you guys are watching me on Kick and Twitch, come over to YouTube, okay? Check me out there. All right. Thanks, guys. I'm going to stop right there. Stopping and stopping. And then now I'm going to see whether this fixes YouTube for the rest of the half hour.
I did.
And I ask that because the file stamp, does that tell us where it was filed? Meaning the RJC, the Regional Justice Center, or the Family Court Building?
It does not.
Okay. But in your capacity and under your purview with your job, you're able to determine those things?
Correct.
And according to your research, where was this document filed?
I made some notes because it's been a long time since I looked at it. Would it be possible to review the note on the date?
Do you have your notes with you?
It's just a piece of paper.
An objection to reviewing those without prior authentication.
Your Honor, this would just be refreshing recollection. You wouldn't be reading it out loud to the jury.
Show it to the defense counsel.
Haven't seen it, has been filed.
That's.
I don't have objection to her reviewing the notes and refreshing the recollection for whom she'll testify that she made these when the information was refreshed. I would also ask that a copy of this document be made. What is court exhibit?
That's fine.
foundation for that, Your Honor?
It's just,
Is that, okay, I'm just making sure. So I understand you're looking at a piece of paper, is that correct?
Yes.
Okay. Is that your handwriting on the piece of paper?
Yes, it is.
You made those notes yourself?
I did.
And was that made during your research regarding certain filings for this case?
Yes.
Move to admit, Your Honor?
It's not being admitted, it's just
Or
used to.
just to be used to refresh recollection, is that
it hasn't
sufficient
been-
of a foundation?
It's my understanding.
That's correct. My colleague hasn't established that it does in fact refresh your recollection for this. She actually knew it at one time.
I think, Your Honor, there's some confusion. because
Objection,
there were-
one witness per attorney.
Sustained.
What?
That's fine, Your Honor.
Oh my
Looking at these
God,
notes that you made
really?
yourself in regards to this case, does that refresh your recollection?
Yes, for the date.
Go ahead. I'm overruling the objection, assuming that's what your objection was.
No, if the foundation is properly lit, if you refresh recollection, I would probably have to know.
All right.
Ms. O'Connor, going back to State's Exhibit 3, it's being published here. Where was this, according to your research, where was this document filed?
This document was filed at the customer service counter at the Regional Justice Center.
Showing Exhibit 4, which has been previously admitted. What does the file stamp there tell us about this document?
That it was filed at one of our customer service counters,
And what date was that?
December 20th of 2017.
And again, who was the party filing that document?
It's listed as Michael McDonald.
And publishing State's Exhibit 5, which has been previously admitted. Same question, Ms. O'Connor, what does the file stamp there tell us about this document?
That it was filed on March 13th of 2018 at one of our customer service counters.
And who was the party filing that document, according to this?
It's listed as Michael McDonald.
Showing you State's Exhibit 6, which has been previously admitted.
Nikki, thank you for
Same
becoming a
question, what does
member.
that file stamp tell us about that document?
It was filed on March 21st of 2018 at one of our customer service counters.
And again, in regards to this document, do you recall where this was filed?
I believe on this document, it was filed at the family court's location.
Your indulgence, Your Honor.
Your Honor, I would put up 2 final points. You said believe, but you know, if you believe, then I move to strike.
Are you objecting?
Yes, there's no penalty.
Sustaining the objection.
Thank you, Your Honor. You say you believe, Ms. O'Connor. Were you also, did you do some research to try to determine where this document was filed?
Yes,
And what was the result of that research?
at the family court location.
All right, withdraw.
And I apologize, going back to State's 5, which has been previously admitted. The same question, Ms. O'Connor.
Okay, so it seems like it really was the multi-streaming that's causing the issue.
According to your research into the history of this document, where was this document filed?
At the family court location as well.
We spoke a little bit about the JAVS video surveillance system that is in the courthouse and at the family courthouse. Were you asked at one point to obtain or pull video from a hearing that occurred on March 16th, 2018?
Yes.
And was that in relation to Michael McDonald, the defendant in this case?
It was in relation to that domestic case number, yes.
Did you in fact make a copy of that video and give it to my office, the
Yes.
district attorney's office? Did you then meet with myself and Ms. Mishler and view portions of that video that had been redacted and kind of cut down and view that in its entirety with us?
Yes.
Permission to approach, or I'll show defense counsel. Permission to approach?
Yes.
Showing you State's proposed Exhibit 7. What does that appear?
A CD
When you say that, how do you know that? Is this, what are we looking at here on the bottom of the disc?
Those are my initials and the date that I reviewed it.
Did you in fact write that yourself?
I did.
And was that after you viewed what's on this disc in its entirety, Commissioner's presence?
Yes.
Move to admit proposed 7, Your Honor.
Objection.
Are we gonna show it to the jury?
I'm sorry?
Are we gonna show it to the jury?
If it's admitted, yes.
Okay, then we'll show it to it, okay.
If it admitted.
Thank you, Your Honor.
This guy.
Brief indulgence. Nothing further, Your Honor?
Ross.
Family worked on the family court for a number of years, you know?
I have, yes.
Okay. And for those of us who don't get down to family court so often, can you explain a few things to me if you don't mind?
Okay.
You know, is it common for people to have attorneys in family court?
We do see attorneys, but the majority, I think, of folks also appear in proper person.
And when you say proper person, what does that mean?
They're self-represented.
All right, you're self-represented. That means a lot of people can't afford an attorney. All right. Now, how many documents a day do you guys take in down there in family court? Just near 100 or 1,000 will be fine.
I haven't given up on streaming on multiple platforms, but I may have to sign up for like something like Restream to do it. I think the problem is that the plugin that I have for OBS allows me to do a multi-stream, while it allows me to use while the multi-stream thing uses the same encoder, so it's not like it's doubling up on the CPU resources or the GPU resources to do the upload. It's still requiring like 6 megabits per second for YouTube, 6 megabits per second for Twitch, and 6 megabits per second for Kick, which obviously I don't have the resources for that because Comcast are pieces of... I'm gonna not curse, but yeah, I think that's the issue. It's my limited upload speed that's inhibiting my ability to simulcast.
It really fluctuates depending on the day. And can I ask, do you mean across the counter or just total?
Divided by on working days. I'm not interested in the day after a holiday or anything. I mean, just how many documents a day do you guys process of it?
Approximately 2,000 to 3,000.
2 to 3,000 documents a day. So how many working days a year?
I don't know that off the top of my head.
So we got 50. So we got 52 weeks, about 3,000 documents a day, give or take. You know, would you agree with that there's about 750,000 documents get filed with family court every year?
I don't know that off the top of my head.
Do you remember when I asked you about this at the preliminary hearing?
I don't actually. I'm sorry.
Okay. So you would agree 3,000 to 3,000 documents a day?
Approximately, yes.
Okay, and they can be filed from the family court. They can be filed from this building down to the family court, which is actually not here, correct? Now, going through, counsel, where's your exhibit? Showing you State's Exhibit 2. Okay, what date was that filed?
September 27th of 2017.
Okay, and this is for Mr. McDonald to try to get custody visitation with his kids, correct?
I don't know the substance of the document.
Don't know the substance. And when was this document filed?
March 13th of 2018.
And this is actually just exhibits to the case, exhibit. Correct.
That's the title of the document, yes.
Right. Now, there's a term here, and I want to understand something, if you help me understand. The term here is on the top, it's called recusal. What does that mean?
I guess I'm not understanding the question.
I'm trying to make it as simple as I can. What is it? The very first term, first word in the upper left corner of that particular document is the word recusal.
Correct.
Could we hear what exhibit number we're talking about?
Certainly, counsel, I apologize. That would be stage 3. Okay, the word again is the word recusal. The document date is on the 12th of, or 4th of March, 4th of April, again, 4th of December, 2017. Now, what is a recusal?
Recusal is usually a request to have the judicial officer assigned to the case recused.
Okay, the judicial, and without, for the non-lawyers here, a judicial officer would be a judge. Correct?
Could be, yes.
Yes. And there's, so basically that document is a motion to recuse a judge. That's what his caption reads, correct?
Yes.
All right. And showing you what's been marked as proposed exhibit number 4.
Okay.
This document is called a reply. What's the caption here?
Defendant's reply to response to motion to disqualify and counter motion.
Okay. Now, I'm going to go out on a limb here, but I suspect sometimes down in family court, the motions run pretty high. Correct? I mean, you've been down there a number of years. All right, and I would suspect people getting frustrated, maybe throwing things and kicking things, happens fairly frequently.
Where are you going with this?
Now, you can't say for sure who actually filed those documents, only that they were in fact filed.
Correct.
Now, I'm a little confused. If I had ill feelings towards somebody, could I go down and just file something in their case?
We don't require ID if
Okay.
you're filing at any of our customer service counters.
So if I wanted to file something that was kind of really unkind about somebody or something, I could, and I wanted to cause some mischief, I could go down and just file something in an electronic file, correct?
It would be processed through.
All right. Well, let me ask you a question. What is a fugitive document?
I'm not fully comfortable on the definition of that term.
Okay, well, if I'm representing somebody as an attorney, and they're not happy with me, and they file their own motion without telling me, are you allowed to accept that?
As a clerk's office, we're required to accept any documents that are filed. It's up to the judicial departments to make any decisions.
So it would be the court, the parliament, that would actually reject a document that was not probable.
Correct.
All right, is that the fact what they mean by fugitive document?
It's my understanding, but I'm not confident on the full definition of that. It's not something we normally handle.
Now, you down in family court every single day, correct?
Well, not, I mean, every single day is kind of broad. I have staff at other locations.
I'm assuming they give you a day off. That wasn't what I meant. They do it when you're at work day. This is what you do. You get up, you go down to family court and run the clerk's office.
I do.
Okay, so that's what you do. Now, are you familiar with an organization down there called Nevada Court Watchers?
Uh-oh.
No, I'm not.
No. Do you ever get on the internet and read up on family court at all?
No.
Okay, so nothing that you do.
Uh-oh.
Mr. Miller, we need you to put the lapel mic on. You're wondering out of areas where she can't take you.
Not a problem. No one will ever complain they can't hear me. Please let voice.
Up. Loud.
All right, now I got the microphone on. I think I'm just about done. Give me a moment or two. Now, if someone's attorney dies or they don't no longer have representation, is there ever a family court that teaches them how to do anything? How to file motions or how to put things together?
I don't know the answer to that.
Okay, so you're the technician behind the clerk's counter. You make sure everything goes where it's supposed to, but you don't actually get involved in the function of the court.
Not in the question that you posed to me about training people.
Okay. So
That's not a function that the clerk's office does.
nothing, right? And nothing that you oversee. All right, and since you're down in that building every day, do you know?
Right on, guys.
Somewhere in the building where people, you can send people who need advice? Right, and what is that section called?
It's called the self-help center.
All right, and so by law, if I'm getting divorced and I don't have any money and I want some help from you at the clerk's window, are you allowed to give it?
We cannot give legal advice, no.
All right, so, look, tell me, what am I gonna do? And I'm upset and I'm nervous because, what is your response? What's the clerk's standard response to that?
We would refer them over to the self-help center.
Okay, and what exactly is the self-help center?
It's a office area that's.
I think, Brad, I think people in chat said that Mueller is taking this case pro bono. At least for this. So for this attorney, it doesn't look like McDonald is paying for him.
The family self-help center is located at the family court location.
Certainly getting his money's worth.
In cases occasionally get rescheduled.
Continue.
Yes,
Is that-
continue to reschedule. Say the judge wasn't feeling well or somebody was in a car wreck on the way to court, do they get rescheduled?
Yes, I was.
All right, and you routinely have to reset court dates?
My staff do, yes.
Your staff does, I know. You, that's the royal you and your staff, okay, I apologize, the royal you. All right, at your office, one of the things you do is reset court dates when things have to be changed.
Correct.
Now, sometimes people file documents, and the file and the contents of the documents, what was true when they were filed necessarily isn't true in the future, correct?
Cowboys won.
Don't know.
as they're supposed to when they're playing the Giants.
Filing, I filed myself, and then I win $1 million megabuck machine 2 days later. Do I have an obligation to update that information?
That I don't know.
You don't know. All right, do you ever receive updated financial information file?
Yes.
Okay, so it does happen. Okay.
Is it yes?
Yes, I'm sorry.
Shaking your head doesn't come out on the audio.
Now, I asked you before when you testified at a preliminary hearing, this is the first time you've ever testified in a criminal case, correct?
Correct.
And how many years have you been doing this?
With the clerk's office?
With the clerk's office.
7 years.
7 years.
Just over 7
And
years.
you're 7 years in charge?
Yes,
Okay, and then before you were in charge, presumably you worked your way up through the ranks?
correct.
All right, and how many years in the clerk's office total?
I don't know that number off the top of my head.
Okay, what year did they hire you?
Well, I've been with the courts just over 21 years, but I've worked in a multitude of areas.
All right, and in the clerk's office, how long have you worked there?
In the past, I honestly can't give you that number. I don't know off the top of my head.
You don't know how long you worked in the clerk's office? Within a few years. Okay. I have nothing further.
Redirect. Rebuild the term.
Or just hold it up and the microphone back up. Coding.
Just very briefly, Your Honor. Ms. O'Connor, you're not a lawyer, correct?
No, I'm not.
You didn't go to law school?
No.
There was a question asked about, you obviously can't get legal advice, but there is a self-help center.
Correct.
Are you aware, is there other places in town that offer free advice and free help to go for livings?
Yes.
Nothing further, Your Honor. Nothing further.
Questions from the jury? Raise your hand if you have a question. I don't see any questions. Thank you. You may step down.
Watch your step when you come off, Mr. Conley.
Yeah, Steve, can you get the anyone else? On any subject connected with this trial, or read, watch, or listen in a report of, or commentary on this trial, any person connected with this trial by any medium of information, including without limitation, newspapers, radio, television, internet, do not form or express any opinion on any subject connected with the trial until the case is finally submitted to you. We'll see you back here at 1 o'clock.
Folks, please leave your notebooks and pens. Leave your notebooks and pens. Make sure that you grab your
Ms. Rice for the jury.
Your lunch, your lunch out.
Is that it? You know, I think if that's it, then I think that's actually a perfect place to stop. It's 8:22. Yeah, because the next video is 2 hours long. The same same day. So we're gonna stop here. It's clear that it's the multi-stream that's causing the issues. I'm not giving up on my Twitch or Kick channels by any means. I'm just going to be more judicious about, you know, when to stream on which platform and how I'm going to be able to do that. If I can simultaneously stream like at least maybe 2 platforms, not all 3. But we'll figure that out as we go along. But I want to thank you guys. Sathael, you are a madman for all of the gifted subs. I can't believe you sent all of that. Brad, no, unfortunately, I actually do have to go to work tomorrow, so no super long stream tonight. Sathael, you've been so much help. Thank you guys so much for your generosity and your donations. They've really helped me out, especially over the last couple of months. I think about half. I'm more than halfway to 75 on Kick, so that's pretty good. I already showcased Winston. He's already upset with me for picking him up and bringing him in here. So we'll have to wait for that. I mean, I've been streaming 3 straight days. I think I feel like I really need a break. So I don't even know if I'm gonna stream tomorrow. I'm probably gonna stream on Tuesday and Wednesday though, at the very least. But I want to thank you guys for watching. Thank you so much. I will check you guys later. Hope you have a good one, okay? Take care. Hit that like button on your way out. See ya.